Thank you for attending today's civil rights training. Let's turn to the agenda on the next slide. I am not going to read every slide verbatim. In most cases, I will explain what is seen on the slide. We will be covering the definition of civil rights and the laws and regulations regarding same, as well as the areas of compliance we must adhere to. We'll also discuss customer service and conflict resolution suggestions. Civil rights are the protections and privileges of personal power given to all citizens by law. As civilizations emerged and formalized through written constitutions, some of the more important rights were granted to citizens. When those grants were later found inadequate, civil rights movements emerged as the vehicle for claiming more equal protections for all and advocating new laws to restrict the effect of current discriminations. Goals of civil rights: equal and consistent treatment for all applicants and beneficiaries, knowledge of rights and responsibilities, elimination of illegal barriers that prevent or deter people from receiving food, and to provide an atmosphere of dignity and respect for all. Be careful of perceptions of favoritism, even if it is unintentional. The purpose of this civil rights instruction is to establish and convey policy and provide guidance and direction to the United States Department of Agriculture, Food and Nutrition Service, that's USDA FNS, and its recipients and customers, and ensure compliance with and enforcement of the prohibition against discrimination in all FNS nutrition programs and activities, whether federally funded in whole or not. Equal Employment Opportunity, EEO, has to do with employment only, and so is not interchangeable with civil rights. Stereotyping is the preconceived or oversimplified generalization involving beliefs about a particular group. These can be either positive or negative generalizations. Here are some we may have heard. Bureaucrats are paid too much. People from New Jersey talk too fast. People who don't understand English are stupid. Someone who is unemployed is lazy. The danger of stereotyping is that it ignores people as individuals and categorizes them as members of a group who supposedly think and behave the same way. We may pick up these stereotypes from other people, maybe our own families. Prejudice is a set of rigid and unfavorable attitudes toward a particular group that is formed without considering facts. Prejudice is learned. We are not born prejudiced. We may have learned attitudes about an entire group based on our interaction with one person. For instance, my grandmother's crazy, so all elderly people are crazy. Discrimination is acting on these beliefs, the practice of treating persons differently because we have grouped them in our minds according to our prejudices. Discrimination is also the act of violating someone's civil rights. Civil rights laws and regulations were written to prohibit and prevent discrimination against people who participate in federal programs. Programs and activities receiving federal financial assistance must abide by civil rights requirements. Title VI of the Civil Rights Act of 1964 states, "No person in the United States shall be discriminated against on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity." Example, treating or speaking to a person differently, using slang for example, or in a friendlier manner because of race or color. Title IX of the Education Amendments of 1972 states, "No person in the United States shall, on the basis of sex, gender, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance." Example, you shouldn't offer smaller portions to women compared to men. The same size portion should be offered to each. Section 504 of the Rehabilitation Act of 1973 added disability to Title VI. Title II and Title III of the Americans with Disabilities Act of 1990 extended the requirements to all services, programs, and activities of state and local governments and prohibits discrimination based on disability in other public services. The Age Discrimination Act of 1975 provides, "No person in the United States shall, on the basis of age, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." The Civil Rights Restoration Act of 1987 clarified the scope of the Civil Rights Act of 1964. Congress passes a law, and departmental agencies like USDA have to write regulations to implement them to the programs they run. The USDA codified, organized in writing, the U.S. Civil Rights Laws and Regulations into Departmental Civil Rights Regulations, known as the Code of Federal Regulations, Title VII, Agriculture, Part 15, Non-Discrimination, or 7 CFR 15. Specifically, non-discrimination in federally assisted programs of the Department of Agriculture. USDA regulations that implement Title VI are at 7 CFR 15, subparts A through F. Also, civil rights requirements are generally incorporated into program regulations. The Food and Nutrition Service of USDA developed FNS Instruction 113-1. The purpose of this instruction is to establish and convey policy and provide guidance and direction to the United States Department of Agriculture Food and Nutrition Service and its recipients and customers, and ensure compliance with and enforcement of the prohibition against discrimination in all FNS nutrition programs and activities, whether federally funded in whole or not. Civil rights requirements are also incorporated into specific program regulations at Title VII of the Code of Federal Regulations in Parts 250, Donation of Foods for Use in the United States, its territories and possessions, and areas under its jurisdiction, and 251, the Emergency Food Assistance Program, TEFAP, and 247, Commodity Supplemental Food Program, CSFP. Discrimination in TEFAP and CSFP is treating program applicants or participants differently based on one or more protected classes. A protected class is any person or group of people who have characteristics for which discrimination is prohibited based on a law, regulation, or executive order. Protected classes in TEFAP and CSFP are race, color, national origin, age, sex, and disability. Be prepared to provide appropriate information in alternative formats for people with disabilities if needed. For example, Braille or audio for the visually impaired, or simply reading materials to them out loud. We will discuss this more in a few minutes. In order to receive federal funding, agencies and providers must sign assurances promising that they will abide by civil rights requirements in program delivery. Basically, the language states that the entity agrees to operate without discrimination, to comply with all of the applicable laws, which includes compiling data, maintaining records, submitting reports, and allowing federal reviewers access to records. These assurances must be included in all agreements between federal and state agencies and state and local agencies and subrecipients. The agreements you have with your lead agency include the required assurances. All FNS assistance programs must include a public notification system. The purpose of this system is to inform applicants, participants, and potentially eligible persons of program availability, program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. You must inform potentially eligible persons, applicants, participants, and grassroots organizations of programs or changes in programs, including information pertaining to eligibility, benefits and services, the location of local facilities or service delivery points, and hours of service. In addition, public notification must include information on applicants' and participants' right to file a complaint, and the process and procedures for filing such a complaint. Also, all information materials, including websites used to inform the public about FNS programs, must contain the USDA's non-discrimination statement. You must prominently display the "And Justice for All" poster. The poster provides the USDA address and phone numbers that the public can use to file a complaint if they think their civil rights have been violated. The poster must be displayed in an area visible to program applicants and participants, not just in the director or manager's office. You must provide appropriate information, including web-based information, in alternative formats for persons with disabilities. You must include the required non-discrimination statement, which we will discuss in a minute, on all appropriate publications, websites, posters, and information materials provided to the public. Be sure to convey the message of equal opportunity in photos and other graphics that are used to promote program information to applicants or participants. For example, show participants of different races and gender attending or utilizing the services at your facility. This slide shows the current non-discrimination statement that you should be using. It's noted as 2015 NDS. Please note that the language cannot be changed. Already printed material does not have to be reprinted, but when it is, please be sure to use this statement. In any event, all materials must have the 2015 NDS language no later than September 30, 2016. If sending a public release to a media outlet, it must include the full statement, although media outlets usually don't include it. General rule: if the material mentions an FNS program, it must include the statement. This includes handbook, enrollment forms, menus, newsletters, brochures, ads, flyers, etc. The last line on the slide is the shorter statement that can be used for brief brochures, buttons, posters, etc. But in most cases, the longer version, intact, must be used. Prior approval must be obtained from the lead agency to use the shorter version. This slide shows the shorter version of the non-discrimination statement in both English and Spanish. The shorter version can be used on smaller materials, as I stated previously, but whenever possible, the full version should be used. This slide shows the full non-discrimination statement in Spanish. New versions of the And Justice for All posters have been designed by USDA and are currently being printed. Templates of the new designs are not currently available. There will be separate versions for TEFAP, CSFP, and SNAP food stamps. We have ordered copies from the USDA and they will be provided to you when received. In the meantime, continue to display the current version and, as stated previously, in a prominent location for all to view. This presentation will be updated with the new versions when they are available. What does a civil rights complaint look like? An applicant or participant alleges different treatment based on one or more of the protected classes: race, color, national origin, age, sex, disability. In order to reduce the risk of a civil rights discrimination complaint, ask yourself the following questions each time an applicant comes to your program. Am I treating this person in the same manner that I treat all others? Have I given this person the opportunity to clarify all relevant factors, inconsistencies? Have I told this person exactly what information I need for the intake process? Have I provided the person with information he or she needs to make necessary decisions? There are different types of discrimination. Differential treatment is refusing service or using different eligibility criteria for certain applicants. It's also treating recipients differently based on a protected class. For example, we will not provide you with a food box because you are from Iran, an atheist, or a supporter of Senator X. Disparate impact is discrimination that is non-intentional but has that effect. A rule, policy, or practice may be neutral on its surface, but it impacts the protected class disproportionately. An example: in order to ensure that there are interpreters available, a food pantry wants to mandate that all Russian-speaking participants be served on the second Friday of each month. Reprisal or retaliation means negative treatment of someone because they filed a complaint or complained about discrimination or testified as a witness in a complaint investigation. Retaliation could involve denial of service, harassment, intimidation, etc. Retaliatory behavior can result in a finding of discriminatory retaliation, even if the original complaint filed by the individual is baseless. When a complaint is received at the state or local level, it must be forwarded to the FNS Civil Rights Division, or CRD, within 5 business days of receipt. When the complaint is received, FNS investigates by reviewing records and interviewing relevant state and local agency employees. All involved parties are asked for their version of the incident or issue. Confidentiality at all levels is extremely important. When the complaint is received by FNS, they ask the complainant if it's okay to use their name in the investigation process. Most say okay, and after that they can release the name. When the investigation is complete, FNS writes a final agency decision, either with or without a finding of discrimination, and includes the state and local agencies in needed resolution to close the case. The complainant is informed of the decision and can appeal. A separate log must be maintained for civil rights complaints, separate from other program complaints. This log must be kept by you for 3 years. Applicants and participants must file a complaint of discrimination within 180 days of the alleged action. They can still file if it's over 180 days, but unless there's an allegation of a pattern of discrimination or other extenuating circumstance, the FNS will notify them that they cannot investigate. Here are the links to the USDA complaint form in English and in Spanish. It is not required that the USDA form be used to file a complaint. Complaints can be made via phone, letter, email, fax, or any other form of communication, but you must have copies of the form readily available for applicants or participants to use without having to ask for one. Never discourage groups or individuals from filing a complaint or from telling about a situation of potential discrimination. As long as complainants are assured of their right to file a complaint at the federal level, it's okay to try to resolve the issue at the local level. This is where mediation techniques come in. But my advice, try to resolve if you think it's possible, but hand them a complaint form just in case. That way you're covered. Civil rights training is required so that everyone involved in all levels of program administration understand the related laws, regulations, procedures, and directives. This training must be done on an annual basis and includes staff and volunteers. Frontline staff, for instance, food pantry workers, recruiters, reviewers, and those who supervise frontline staff must receive this full civil rights training, the presentation that we are providing to you today. New staff must receive their training before participating in activities involving distribution of federal food. Staff and volunteers who are not characterized as frontline must also receive training appropriate for their roles and responsibilities. For example, if you have a staff person or volunteer simply greeting the applicants and participants, they do not require the full training as provided here, but must be informed that the applicants and participants are protected under federal civil rights laws and regulations and must be treated with the greatest respect. To reiterate, training requirements for volunteers. Frontline volunteers, such as individuals who regularly interact with program applicants and participants, determine eligibility, or handle personal information, must receive full civil rights training on an annual basis. Training must first occur during each individual's orientation to the program. Volunteers who do not handle personal information and who may infrequently interact with program applicants, participants, or frontline staff must receive at a minimum limited civil rights training which covers customer service and any other subject matter applicable to each volunteer's roles and responsibilities. Training must first occur during volunteers' orientation to the program and through refresher training as needed. Volunteers and staff who do not interact in any way with program applicants and participants and who do not handle personal information do not require civil rights training. An agency that participates in federal food distribution programs is expected to provide annual training to all frontline staff and to be in compliance with civil rights laws. All must have an understanding of their responsibilities to ensure that the civil rights of all applicants and participants are protected. These responsibilities include assurances that all staff will comply with civil rights laws, the development of an effective public notification system, the development of a complaint procedure, make sure everyone understands how to handle complaints of discrimination, a reasonable accommodation for language assistance, the requirements for reasonable accommodation of persons with disabilities, a plan for equal access to programs, a plan for conflict resolution and customer service. For CSFP, you are required to collect the racial and ethnic data of the participants. If the participant does not wish to provide this information, a visual observation by the site representative must be made and recorded. Applicants shall be assured that the information is required for and used for statistical purposes only and has no effect on eligibility criteria. The data should be collected at the point of application and retained at the service delivery area. There are two questions. One is ethnicity, and you must select one of the following: Hispanic or Latino, or not Hispanic or Latino. And then in addition, you must select a race, one or more of the following: American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian or other Pacific Islander, or white. Remember that both questions must be answered. If you do have to do a visual, you can only select one race. You cannot select more than one race. But if someone is providing the information to you, they can select one or more of the races that are shown. You should have a plan to address limited English proficiency, LEP, requirements. Who are persons with LEP? Individuals who do not speak English as their primary language and have a limited ability to read, speak, write, or understand English. All organizations receiving federal assistance have an obligation to reduce language barriers that can preclude meaningful access by LEP persons to important benefits, rights, programs, and services. Failure to provide meaningful access could be discrimination on the basis of national origin. An LEP plan is a strategy for organizations to identify LEP persons who need language assistance, ways the assistance will be provided, how to train staff and volunteers, and provide notice and monitor and update their plans. Factors included in ensuring meaningful access: the number or proportion of LEP people eligible to be served or likely to be encountered by the program, the frequency with which LEP individuals come in contact with the program, the nature and importance of the program, activity, or service provided by the program to people's lives, and the resources available to the recipient and the costs involved. For example, if you find that you have a large number of Hispanic individuals in a district, program materials must be available in Spanish, and ensure that you have Spanish language interpreters available for applications. It's important to remember that LEP applicants and participants cannot be asked to bring their own interpreters. The law requires that the local entity provide interpreters at no cost to the participants. However, community and advocacy groups and churches are often good sources for free or low-cost language interpreters. If an applicant or participant is accompanied by someone who can translate, you can request to use them. You just cannot require that persons provide their own interpreters. Children who are minors should not be used as interpreters. Volunteers may be used, but make sure they understand confidentiality. Some examples of language services: training bilingual staff to act as interpreters and translators, telephonic and video conferencing interpretation services, oral or written translation services, using technological advances such as computers and smartphones to access translation websites, sharing of language assistance materials and services among and between recipients, community organizations, and advocacy groups. The U.S. Department of Justice has a website at www.lep.gov that contains a wealth of useful information for ensuring access to benefits for LEP applicants and participants. This includes downloadable I Speak cards, which allow the LEP individual to point to the language he or she speaks to facilitate finding an appropriate interpreter. Also listed are some government websites you can access to gain more information on the language groups that may be encountered in your service area. It is important to remember that in the context of the Americans with Disabilities Act, disability is a legal term rather than a medical one. Because it has a legal definition, the ADA's definition of disability is different from how disability is defined under some other laws. A person with a disability has a physical or mental impairment which substantially limits one or more life activities, has a record of such an impairment, or is regarded as having such an impairment. Major life activity means functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. A major life activity also includes the operation of a major bodily function, including but not limited to functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. State and local offices must provide necessary accommodations to applicants and participants with disabilities when necessary. Ensure that people with disabilities can get into your agency from the parking lot, entrances, hall, elevators, restrooms, as well as allowing service animals. Arrange ways for people to get services. For example, if your program is in the basement and you don't have an elevator, staff should be available on the main floor. You must provide the same level of service to disabled applicants and participants in an alternative way. It's important to maintain good communication between all involved parties. Any expenditure of funds required for obtaining reasonable accommodation must not be passed on to the applicants and participants. There is an obligation to ensure that members of the public are provided accommodations in order to access program information, applications, and assistance. Examples of reasonable accommodations: allowing the participant to designate a proxy or proxies to pick up their food, conducting telephone interviews or home visits for those who are homebound, captioning or computer-assisted real-time technology, that's CART, services for deaf or hard of hearing clients, providing qualified sign language interpreters for persons with hearing disabilities, reader services for blind or visually impaired clients, or any other kind of alternative arrangement for service. Faith-based organizations, FBOs, and community-based organizations, CBOs, participate in FNS programs through agreements with states or through other local agencies that have agreements with states. Nutrition Assistance Program Policy encourages the participation of FBOs and CBOs on an equal footing with other kinds of local cooperating organizations and avoids barriers that would make their participation difficult. 7 CFP Part 16 ensures a level playing field for the participation of faith-based organizations and community-based organizations in FNS programs. Faith-based organizations can receive federal funds to operate emergency feeding programs, use space in their facilities without removing religious art or symbols. However, faith-based organizations cannot discriminate against individuals on the basis of religion or religious beliefs, use USDA funds or products for religious activities, distribute religious information to clients, or make clients participate in a religious activity in order to receive assistance. These provisions were meant to ensure that federal funding is used strictly for the goals of the program, the delivery of nutrition assistance as provided for in public law. As it applies to FNS food distribution programs, USDA funds cannot be used to preach. In other words, churches and faith-based organizations cannot include religious materials in USDA food boxes, nor can they make a meeting with a pastor a condition of receiving USDA commodities. This last point doesn't mean that you cannot schedule a religious activity such as a prayer service around a distribution. It means that you have to allow sufficient time for your distribution so that those who do not want to participate in the religious activity can still receive their food. For example, you can schedule your distribution to occur between the hours of 10 a.m. and noon, with a prayer service happening between 10 and 10:30. As long as you let your clients know about the scheduled prayer service and the time of distribution outside the prayer service, you will be in compliance. The purpose of compliance reviews is to determine if an applicant organization or recipient organization of federal financial assistance is in compliance with civil rights requirements. The FNS Civil Rights and Program staff reviews state agencies. FNS staff and state agencies review local agencies and subrecipients. Significant findings must be provided in writing to the reviewed entity. There are three types of civil rights compliance reviews: pre-award reviews, post-award or routine reviews, and special reviews. Organizations that apply for the opportunity to operate federal assistance programs must demonstrate their ability to comply with all civil rights laws and regulations prior to receiving approval to conduct the programs. Pre-award or pre-approval reviews for civil rights compliance are required before federal financial assistance can be awarded. New sites must provide information on federal and legal civil rights activities, including lawsuits and complaints, as well as other federal programs applied for, and assurance that records will be available for review when required. Information supplied includes accessibility and demographic data analysis, plans for bilingual access, and civil rights impact analysis when requested by FNS. On-site pre-award reviews by FNS and state agencies can be made when necessary, but are usually conducted as desk reviews. The post-award or routine review content areas are based on FNS Instruction 113-1 and ask the basic question whether potentially eligible persons have equal opportunity to participate in federally funded programs. So the review breaks that question down, not just whether they have the "and justice for all" poster, but can it be seen by applicants and participants? Is the non-discrimination statement on appropriate materials? How do you keep participants aware of changes and complaint procedures? Have you made reasonable accommodation for persons with disabilities? If no wheelchair access, how do you service people with physical disabilities? Has the agency conducted its required annual civil rights training for staff and volunteers? And is there a procedure in place to handle civil rights complaints? What is done if a visually or hearing impaired person requests accommodation? A special compliance review is conducted by USDA's Office of the Assistant Secretary for Civil Rights independently or in conjunction with FNS staff when significant civil rights concerns having a direct effect on the delivery of FNS program services and/or benefits are identified. A special review may be scheduled or unscheduled. Examples of special compliance review circumstances include, but are not limited to, Program participation data indicates that a particular group in a specific area is not benefiting from an FNS program. Reports of alleged noncompliance made by the media, grassroots organizations, or advocacy groups need to be resolved. Reports of alleged noncompliance made by other agencies, such as the Department of Education or Health and Human Services, need to be resolved, or patterns of complaints of discrimination have been documented. A finding of noncompliance may be the result of a routine management evaluation review, a special review, or an investigation. Noncompliance is a factual finding that any civil rights requirement is not being adhered to by a state agency, local agency, or other subrecipient. The following are general examples of civil rights noncompliance or discrimination. Denying an individual or household the opportunity to apply for program benefits or services on the basis of race, color, national origin, age, sex, or disability. Providing FNS program services or benefits in a disparate manner, unless the difference is necessary to comply with non-discrimination requirements, such as disability accommodations. Selecting members for planning and advisory bodies in such a way as to exclude persons from membership on the basis of race, color, national origin, age, sex, or disability. Or selecting FNS program sites or facilities in a manner that denies an individual access to FNS program benefits, assistance, or services. Once noncompliance is determined, steps must be taken immediately to obtain voluntary compliance. The effective date of the finding of noncompliance is the date of the written notice of noncompliance to the state agency, local agency, or other subrecipient. Corrective Action Plans, or CAP. They should outline the action that will be taken to correct any findings, the time frame in which the action will be taken, and how any noncompliance issues will be prevented in the future. CAPs should be submitted to the state within 60 days of the receipt of findings. A failure or refusal to implement a corrective action plan may result in the loss of federal assistance. We have now completed the civil rights training portion of this presentation. Now let's spend a minute or two on customer service and conflict resolution, two subjects that you should cover in your yearly civil rights training with staff and volunteers. Here are some tips for great customer service. Treat everyone with dignity and respect. Welcome them with a smile. Answer any and all questions in a non-threatening voice and manner. Explain all of your policies and make sure applicants and participants understand their rights and responsibilities. Recognize when stress creates a problem and find ways to cope with the situation in a calm manner. Don't feel you need to have the last word. Recognize that everyone is different and your clients will have varied needs and limited resources. Notice when a person feels that they have been treated rudely and acknowledge that feeling. Take steps to improve the situation. Be polite and empathetic and avoid sarcasm. Have a written and posted policy for dealing with unacceptable behavior and conflicts. Here are some suggestions. When answering the telephone, always clearly introduce yourself and never interrupt the caller. Be patient. Give the client the opportunity to explain what happened. Be understanding. An angry client requires the most empathy. Don't be judgmental. Respond in a calm manner. Staying calm should help the client to relax, which in turn allows you to consider and address the facts, not the emotions. Be sincere. It's always okay to apologize to the client for his inconvenience, even if you feel that the problem is not your organization's fault. Be aware. Excuse me, if you feel you are being threatened or if violence is possible, get help immediately. What steps do you need to take when or after talking to the client? Always try and stay calm. Determine the specific issue that you need to address. Find a solution. Know your organization's policy on handling situations and the information needed to offer a solution. Get back to the client and gain approval on the solution. Make an agreement with the client on what is to be done, when it is to be done, and by whom. Follow up with the client to make sure that he or she is satisfied. 3 simple rules. Remain calm with your posture and tone. Try to explain your understanding of the situation. Get help, especially if threats are made or if violence is possible. We have now finished with the presentation for today, and I thank you all for your attention.